Getting Legal Protection from Abuse, Video 5, How to Prepare for the Full Hearing, Subpoenas, and Discovery. You have the right to protect yourself from abuse. This is the 5th part in the series, Getting Legal Protection from Abuse, and will explain how to prepare for your full hearing when seeking a Civil Protection Order, or CPO. Let's break it down. About 1 week after the hearing when you first requested your CPO, the court will schedule another hearing. The second hearing is called the full hearing. In the time between the 2 hearings, the court will send out your petition and the ex parte CPO to the abusive person, also known as the respondent, in person by a sheriff's deputy in the county where the respondent lives. The full hearing is when your abuser has the right to come to court and either agree to the terms of the protection order or to contest, meaning not to agree to the terms. If you are representing yourself in the full hearing, there are a number of things that you can do to prepare. It's very important to be prepared for your hearing so you can explain why you are entitled to a CPO. Make a timeline of the violent things that occurred between you and the abusive person. Include the scariest and most dangerous incidents in your timeline. The timeline is for your reference only. The court will most likely not allow you to read it aloud, but be sure to include details about things that prompted you to come to court. Be very specific, such as, "He punched me in the face and broke my tooth." It's best if you can present other evidence of abuse besides your own description of what happened. This is called corroborating evidence in legal terms. It means you are proving abuse with photos, text messages, emails, or screenshots. Corroborating evidence can also consist of a video or medical record of injuries, or copies of criminal convictions against your abuser. It's also important to present witnesses at your hearing. Are there people who witnessed or saw the abuse or heard the respondent admit to abusing you? If the witnesses are adults who saw one or more specific events, you may decide you want them to share the story of what they saw with the court. They should be able to explain who they saw, what happened, and when and where it happened. Try to talk with your witness before the hearing to make sure they can answer these questions before asking them to attend the hearing. Written witness statements are almost never allowed in court. Your witnesses must appear in person in the courtroom. Be aware that the respondent or their attorney can also ask your witness questions. Were the police called at any time? If the police have ever been called out due to an incident of abuse, you may want to ask them to come to court to talk about what they saw or what the respondent said to them. Try to serve them with a subpoena at least a week before the hearing. If you don't have a full week, try to subpoena them anyway. More about subpoenas in a moment. You might not find corroborating evidence for everything you want the court to hear about, but remember, the court may still award you a protection order based only on your testimony of what happened to you or your children. That's why it's very important that your testimony gives specific details of abuse. There may be other witnesses you want to appear in court, but they don't want to or they need something official so that they can be excused from work in order to go to court. This is when the court will need to subpoena them. A subpoena is when the court orders someone to attend the hearing. You should also subpoena law enforcement officers if they came to your home, spoke with the respondent, or took photos of your injuries. You will want them to personally present those photos to the court. To get a subpoena, contact the clerk of courts in your county for instructions. You will probably be required to complete a short form that describes any evidence or documents you may want the witness to bring. The form will also ask for the name and address of the witness. The clerk will mail the subpoena or arrange for the sheriff to personally deliver the subpoena to the witness. If the respondent is represented by an attorney in the CPO case, it is possible that attorney might send you discovery requests. Discovery is the formal process of exchanging information between you and the respondent about the witnesses and evidence. These may also be called interrogatories, or requests for production of documents, or requests for admissions, or notice of deposition. In a CPO case in Ohio, a party must ask for and receive an order from the court specifically permitting them to send these discovery requests. If you do not receive an order from the court signed by a judge or magistrate with a file stamp on it showing the date and time it was filed, you are not required to respond to any discovery requests you receive. If you receive a court order requiring you to comply with a discovery request, you should follow the directions. You may want to consult an attorney at that time. While it's always best to consult a lawyer, especially if you have children or shared finances with the abuser, this video series, Getting Legal Protection from Abuse, will take you step by step through the process of getting a civil protection order, including how to request help and special accommodations, what to ask for to keep you safe, how to prepare for court, how to present your case, and how to enforce your protection order. Everyone has the right to live free from domestic violence. For more information on protecting yourself and your family, contact your local domestic violence agency. To find your local agency, contact Ohio Domestic Violence Network at www.odvn.org/find-help. You can also contact your local legal aid. To find the legal aid for your county, contact www.ohiolegalhelp.org/find-your-legal-aid. Or if you are in Northwest or West Central Ohio, contact Legal Aid of Western Ohio at 888-534-1432.